Former President Trump faces 91 counts across 4 criminal cases right now, but a separate civil case will go to court now, according to a judge's decision yesterday, this Monday, in 2 days. The witnesses could include President Trump, his 2 oldest sons, Don Jr. and Eric, who have both been involved in his business dealings. The former president is accused in this case of financial fraud. He claims that he has done nothing wrong. His lawyers say that they will absolutely appeal this case, but Trump could, in this case, lose the famous Trump Tower and many of his iconic New York properties. Former federal prosecutor Andy McCarthy calls that the corporate death penalty as a lie.
In 1995, Trump signed a document with the town of Palm Beach. The document converted Mar-a-Lago from a private residence to a private social club. The deed restrictions attached to that conversion are permanent and unconditional. They prohibit the property from being used as a private residential estate. They limit its use to its function as a club. Trump signed it. He knew what he was signing. He agreed to those restrictions in exchange for the conversion. A property subject to permanent deed restrictions prohibiting residential use is worth significantly less than a private residential estate of the same physical dimensions. The most expensive private real estate in America sells at prices driven by one thing: the ability of the buyer to use it as a home. Mar-a-Lago, because of the restrictions Trump himself agreed to, cannot be used that way. From 2011 to 2021, the Palm Beach County tax assessor estimated Mar-a-Lago's market value at between $18 million and $27.6 million. The assessments reflected the property's actual legal status, a social club with deed restrictions, valued as such. On his statements of financial condition submitted to Deutsche Bank, Trump valued Mar-a-Lago at between $426 million and $612 million. In 2018, he told Deutsche Bank it was worth $739 million. Under oath at trial, he said it was worth between $1 billion and $1.5 billion today. That is not a valuation methodology dispute. It is not aggressive but defensible estimation. It is valuing a property as if the deed restrictions Trump himself signed did not exist.
Reality of this case, he's standing by. But first to Lauren Green, reporting live from New York. Hi, Lauren.
Hey, Martha. Well, of all the lawsuits against Donald Trump, this one targets his core identity, his real estate empire. Yesterday, a New York appeals court judge rejected the former president's bid to delay the civil case brought by the state attorney general. So the non-jury trial is set to start Monday. The $250 million case brought by New York's AG Letitia James is against Trump, his eldest sons, Eric, Donald Trump Jr., and other Trump Organization executives. It accuses them of fraudulent business practices. And on Tuesday, the judge basically agreed, ruling that Trump committed years of fraud by grossly overestimating his real estate holdings, accusing him of false and misleading asset valuations, including the value of his Mar-a-Lago estate in Florida, overstating its value by as much as 2,300% on one financial statement.
This investigation revealed that Donald Trump engaged in years of illegal conduct to inflate his net worth, to deceive banks and the people of the great state of New York.
Subscribe and hit the bell. Leave a like, because what I want to work through about how this case was constructed, what the appellate court ultimately did with it, and what the compliance monitor sitting in the Trump Organization's building right now means for what comes next is the full picture most coverage summarized too quickly. Stay with me. The Mar-a-Lago overvaluation is the most dramatic finding because of the deed restriction dimension. But the Trump Tower triplex is, analytically, the cleaner one, because it involves a different category of claim entirely. Square footage is not a valuation, it is a measurement. Buildings are measured. The measurements are in public building records. They do not change based on market conditions, interest rate environments, buyer demand, or any of the other variables that make real estate valuation genuinely complex. The triplex at the top of Trump Tower occupies a specific number of square feet that was measured, recorded, and available in public documents. The public records showed 10,096 square feet. Trump's financial statements listed approximately 30,000 square feet. That is not an aggressive estimate. That is tripling a documented number. The valuation consequences flow directly from the square footage. A larger apartment in Trump Tower is worth more than a smaller one. By listing the apartment at 3 times its documented size, Trump generated a valuation that was between $114 million and $207 million higher than the property's actual value. Engoron's calculation. Engoron's finding, A discrepancy of this magnitude in a developer's assessment of his own living space maintained over years can only be considered fraud. That conclusion requires sitting with for a moment. Engeron is not saying aggressive valuation methodology crossed a line. He is saying a person who has lived in a space for decades, who uses it as the backdrop for his entire public identity, who has shown it on national television, does not accidentally list its square footage as 3 times the documented measurement. The triplex finding strips out every complexity that makes real estate fraud arguments feel ambiguous. Square footage is not complex. The measurement is in the record. The statement is in the record. They do not match. The no victims argument requires addressing directly because it was Trump's most persistent public response to the case, and the precise answer to it matters. Deutsche Bank was the primary lender. Between 2012 and 2015, the bank extended Trump approximately $2.5 billion in loans. The Trump International Hotel in Washington, the Doral Golf Resort, the Trump National Golf Club in Chicago. These loans were made on the basis of financial statements that Engeron found substantially overstated Trump's net worth. The bank's own analysts had reservations about Trump's financial representations. Internal reviews flagged concerns. The bank continued the lending relationship anyway, partly because it was extremely profitable. Trump's team argued that the bank did its own due diligence, that sophisticated lenders are not victims in the traditional sense, and that the bank's continued willingness to lend undermined any claim of fraud. The prosecution's expert witness calculated something specific. Deutsche Bank received approximately $168 million less in interest over the life of the loans than it would have received if the financial statements had been accurate. At accurate net worth figures, Trump would have been assessed a higher risk rating and charged a higher interest rate. He was charged a lower rate because the bank believed he was worth more than he was. $168 million in interest that the bank was entitled to but did not collect, because the financial statements it relied on were false. That is the precise answer to no victims. Not that the bank was naive, that the bank, relying on statements it had no way to verify in detail, extended credit at terms that were better than accurate information would have justified. The $168 million is the measurable gap between what happened and what would have happened if the statements had been true. The non-jury structure deserves specific treatment because it affects how the verdict should be understood. Most people think of trials as involving juries. In this case, there was none. New York civil fraud cases brought by the Attorney General under the specific statute James used are generally tried to the court without a jury. This is a legal feature of the statute itself. Equitable actions decided by judges rather than juries. Trump wanted a jury. His team argued the constitutional right to a jury trial applied. Engeron disagreed. The appellate court reviewed the issue and found the non-jury format proper under the statute and applicable case law. What the non-jury structure produced is unusual. Not 12 random New Yorkers rendering a general verdict, guilty or not. A single judge who spent weeks hearing evidence and then wrote 92 pages explaining precisely what he found and why. Every major finding explained, every valuation analyzed, every document described. The appellate court reviewed those 92 pages in detail and upheld the fraud finding. That means not just Engeron, but a panel of appellate judges concluded the record supported the fraud conclusion. And then they threw out the entire financial penalty. The August 2025 ruling is the outcome the document correctly describes, and that requires honest treatment because it is where most coverage stops paying attention. The appellate panel affirmed the financial statements were false. Trump knew they were false. He submitted them intentionally to obtain better lending terms. Fraud confirmed. The $354 million disgorgement, which had grown to over $500 million with interest, was eliminated entirely. Not reduced. Gone. The panel found the figure was not supported by the record as a proportionate measure of unjust enrichment under the Eighth Amendment. The specific transactions for which unjust enrichment could be precisely quantified did not add up to what Engeron imposed. What stays? The compliance monitor, the officer bans, the loan restrictions. Barbara Jones, retired federal judge, appointed as compliance monitor, is reviewing loan applications and financial practices. The Trump Organization cannot apply for new loans in New York without her review. Eric and Donald Trump Jr. cannot serve as officers or directors of New York corporations during their 2-year ban periods. The organization cannot install Trump family members in those roles during the ban. The properties still exist. Trump Tower is still Trump Tower. Mar-a-Lago is still operating. The business continues. But it continues under the eyes of a federal judge who reviews every significant financial transaction. The reporter's framing at the beginning of this document was precise. This case targets his core identity, his real estate empire. The finding the record produced is equally precise. That identity, that empire, was built in part on a decade of financial statements that overstated its value by between $812 million and $3.6 billion per year, depending on the year. Fraud confirmed. Penalty gone. Monitor watching. The empire still stands. What it stands on is in the record now, reviewed and confirmed by an appellate panel. Whether that matters depends on what you think the record is for. Commentary based on confirmed Mar-a-Lago deed restrictions signed by Trump 1995, prohibiting residential use verified, confirmed Palm Beach County tax assessor 18 meter 27.6 meters verified, confirmed Trump financial statements 426 meter 612 meter verified, confirmed Trump under oath 1B 1.5B verified, confirmed Trump Tower triplex public records 10,996 SQFT financial statements approximately 30,000 verified, confirmed 114 M 207 MAB orders valuation inflation from square footage error Engeron finding verified, confirmed Deutsche Bank 2.5B loans 2012-2015 verified, confirmed 168 meter interest calculation. Expert witness verified, confirmed 812 2.2B annual overstatements, 10 years 2011-2021 verified, confirmed 16 defendants Eric Don Jr. found liable 2-year officer bans 4 mailers each verified, confirmed Weiselberg permanent ban 1 mailers verified, confirmed Trump 354 mailer disgorgement verified, confirmed 92-page Engeron opinion verified, confirmed non-jury structure statutory basis verified, confirmed August 2025 appellate ruling fraud, confirmed penalty thrown out 8th Amendment grounds verified, confirmed compliance monitor Barbara Jones loan restrictions officer bans remain verified. The corporate death penalty framing, the former federal prosecutor's phrase in the clip, is worth examining because it is what did not happen and why. James sought to dissolve the Trump Organization's New York business certificates. That would have been the functional end of the organization's ability to operate in New York, effectively the death of the corporate entity in its home state. Engeron did not impose that remedy. He imposed what he did impose, the monitor, the officer bans, the loan restrictions, as an equitable alternative to dissolution. The question of why he chose supervision over dissolution is worth being precise about. Equitable remedies in cases like this are calibrated to prevent future harm while not being disproportionately punitive relative to the conduct found. A compliance monitor reviewing loan applications and financial practices is designed to prevent the specific conduct that produced the fraud, the submission of false financial statements to financial institutions, from recurring. It targets the mechanism of harm rather than the organization itself. Whether that calibration is correct is a question the appellate court partly addressed when it threw out the financial penalty as excessive. The penalty was constitutionally disproportionate. The structural remedies were not disturbed. That distinction is important for understanding what the case actually produced. The financial consequence Trump feared, hundreds of millions of dollars potentially requiring asset sales, is gone. The structural consequence, ongoing court supervision of every loan the Trump Organization applies for, is permanent. Which of those two matters more depends on what the Trump Organization needs to do next. If it needs to borrow money for real estate development in New York, the monitor is a significant operational constraint. If it can operate without new major New York borrowing, the monitor's presence is bureaucratically burdensome but not existentially threatening. That operational question is not resolved by the court record. It is determined by whatever the Trump Organization's actual financial needs are going forward. The 10-year duration of the fraud, 2011 to 2021, is worth sitting with because it tells you something about the corporate culture the case exposed that goes beyond the individual valuations. This was not a single false statement. It was over 200 false and misleading valuations across a decade, submitted annually to multiple financial institutions. The annual statements of financial condition are not one-off documents. They are prepared each year with the participation of accountants, lawyers, executives. They are reviewed before submission. They require signatures. In an organization that prepared these statements correctly, someone with access to the Palm Beach County tax assessor's public records would have noticed that the Mar-a-Lago valuation did not match any external benchmark. Someone familiar with the Trump Tower building would have known the triplex square footage. The 16 defendants named in the original lawsuit reflect this. Weiselberg as chief financial officer, McConey as controller, Eric Trump overseeing specific transactions, Don Jr. signing documents. The fraud was not the work of one person making individual decisions in isolation. It was a pattern of conduct involving multiple executives across multiple transactions over 10 years, all producing the same directional result: inflated net worth on statements submitted to lenders and insurers. Engeron's 92-page opinion documents that pattern across the full decade with the specificity of someone who had read every relevant document in detail. The appellate panel read that 92-page opinion and affirmed the fraud finding. The no victims argument fails most precisely here. Over 10 years, across over 200 false valuations, through multiple lenders and multiple insurance companies, the pattern produced measurable financial benefits, lower interest rates, better insurance terms, that the counterparties would not have provided at accurate net worth figures. $168 million in Deutsche Bank interest alone. That number covers one relationship. The pattern reached more broadly than one lender. There is a specific tension in the final outcome that the document frames correctly at the end. The empire still stands, and the monitor is watching. That tension is not ironic. It is the intended result of equitable remedies in civil fraud cases. The goal is not destruction of the entity, but correction of the specific practice that produced harm and prevention of its recurrence. The compliance monitor achieves that, theoretically. Every loan application reviewed, every major financial transaction subject to oversight. The specific mechanism that allowed false financial statements to produce better lending terms is disrupted by the presence of a retired federal judge who now has to sign off on significant financial decisions. But the finding that produced those remedies, fraud on the financial statements submitted to banks and insurers for a decade, is now in the permanent legal record of the New York court system. It was found by a trial judge, confirmed by an appellate panel. It does not expire with the officer bans or the loan restrictions. Any bank that now considers lending to the Trump Organization, any insurer that now considers writing policies on Trump properties, any business partner that now considers significant transactions with the organization, they can find that record. They can read Engeron's 92-page opinion. They can read the appellate panel's confirmation. The financial institutions that advanced credit based on the false statements did not have access to that record when they made their decisions. Future counterparties will, whether that changes behavior, whether it changes lending terms, insurance rates, business partnerships, is the forward-looking question the record cannot answer. Markets make their own assessments. The assessment the court made is permanent. One more thing about the deed restrictions that I keep returning to, because it is the element that most clearly distinguishes this fraud from the kind that can be explained as methodology disagreement. Real estate valuation is genuinely complex. Comparable sales analysis, income capitalization, cost approach, different methodologies produce different results. In high-end unique properties with no close comparables, valuation ranges can be wide. A court does not typically find fraud simply because an appraiser used an aggressive methodology. The Mar-a-Lago deed restrictions remove that complexity entirely. The restrictions are not a valuation input that can be weighted differently by different methodologists. They are a legal constraint on the property's use that any legitimate appraisal of the property must account for. A property that cannot be used as a private residential estate cannot be valued as one. Any appraisal that ignores permanent deed restrictions and values the property as if it could be converted back to a private estate is not aggressive. It is wrong, and provably so by reference to the public deed records. Trump's own signature is on those deed records. He executed the conversion agreement. He accepted the restrictions in writing. His financial statements valued the property as if those restrictions did not exist, or as if they could be removed at will. Engeron's finding: there is no legal gray area surrounding the permanent nature of the deed restrictions, is the most legally precise finding in the entire case because it forecloses the methodology defense. You cannot argue that a different methodology would have reached the same valuation when the constraint that makes the valuation impossible is in the public record and in Trump's own handwriting. The triplex square footage is the other instance of the same principle. Not methodology, physical measurement. The building was measured. The number's in the record. The financial statement said 3 times that number. Both findings share the same character, not aggressive valuation that crossed a subjective line, but statements that contradict publicly documented facts that any review of available records would have revealed. That is what Engeron meant by can only be considered fraud. Last thought, and it follows from the reporter's framing at the start. His core identity, his real estate empire. Trump built his public identity on a specific claim that he was worth an extraordinary amount of money, that his properties were worth extraordinary amounts, that the name on the buildings represented real value backed by real assets. The art of the deal was built on that identity. The Apprentice was built on it. The 2016 campaign was built on it. "I'm really rich," said directly to camera at the announcement. The civil fraud case found that for a significant portion of the decade during which that identity was being publicly projected, the financial documentation behind it was false. The net worth he claimed to banks, and implicitly claimed to the public, was inflated by hundreds of millions to billions of dollars per year. The appellate court confirmed the fraud and threw out the financial penalty. What that specific combination means is this: the factual finding is permanent. The financial consequence is gone. The identity claim, "I'm really rich," built on statements that courts have now found were false, is in the legal record as having been fraudulent for a decade. Whether that matters to the people who believe the identity claim depends on whether they follow the legal record.